So we're here in St. Paul, Minnesota. We're about to provide service on the Minnesota State Supreme Court on behalf of the affected litigants here within the state of Minnesota. When a state chooses to enact its own alternative legislation and then substitute it for the provisions and guarantees of the United States Constitution, that would be a seditious act. Sedition is defined as the speaking or writing of words, such as law established, in order to cause disaffection to the Constitution to procure its alteration other than lawful manner. There's one way to change the Constitution of the United States of America, and that can be found in Article 5, the special amending procedure of the Constitution. Any other way is an act of sedition done by traitors to the nation. States do not have the authority to enact their own alternative legislation and then substitute it for the provisions and guarantees of the Constitution, and then deprive United States citizens of rights that are guaranteed to them through the Constitution for the United States of America. Here in the state of Minnesota, they are choosing to charge by way of information, not by indictment, as required by Clause 1 of Amendment 5 to the United States Constitution. Clause 1 of Amendment 5 says, no person shall be held to answer for a capital or otherwise infamous crime unless on presentment or indictment of a grand jury. That's clear. You must have an indictment by a grand jury before arresting someone and holding them over for a capital or infamous crime. So when the state enacts its own alternative legislation that permits the prosecuting attorneys to charge by way of information, not by indictment as required by the Constitution, that would be a seditious act. Then, when their agent, the prosecuting attorney, chooses the incorrect charging instrument by relying upon the inferior state law to charge a person with the incorrect charging instrument, they just committed a crime. It is called Deprivation of Rights under Color of Law, Title 18, subsection 242, which states any person who, under the color of any state statute, ordinance, custom, or regulation, deprives the person of rights secured by the Constitution, commits that crime. This is a per se crime, meaning that we don't have to prove that they intended to breach their obligation. Simply by virtue of the breach, all elements of crime have been met because their willfulness and knowledge derives from the promise that they make upon entering their office with fidelity with and to the Constitution for the United States of America. So we have a very, very significant issue here that is affecting hundreds of thousands of people of the state of Minnesota, and we must get this addressed. There are 23 states across the nation today that do not conduct a grand jury, despite the fact that that is required and constitutionally obligated by the states in the adjudication of crimes. There are more than 700,000 people across the United States of America today that are being held illegally and unconstitutionally on convictions that are not valid. They are void because the state did not follow the proper procedures of process established and codified in the Constitution of the United States for the adjudication of crimes. We must get this addressed. So here in just a moment, we're going to be providing a criminal affidavit on behalf of affected parties here within the state of Minnesota for this issue. We're going to ask the Supreme Court of the state of Minnesota to act in a lawful manner and direct the judicial officers of the state to act in a lawful and constitutional manner, and hopefully we can get a remedy to this without any further litigation. If the court chooses to be negligent and not do anything, then they themselves will become implicated in this criminal matter, because the laws of conspiracy state any person who, having knowledge of any of the wrongs conspired to be done, and who have the power to prevent or aid in the prevention of the commission of same, neglects or refuses to do so, may be joined as defendants in the action. Upon providing this criminal affidavit to an agent of the Supreme Court, we're going to deliver to the clerk. Upon providing this criminal affidavit to the clerk, then the Supreme Court has been notified, because notice to agent is notice to principal. Notice to principal is notice to agent. So we're going to challenge the court now to step up, discharge the duties of their office, fulfill the obligations and promises that they made to the people of the state of Minnesota, and hold criminals accountable for the crimes they commit against the people. Thank you so much.
So Kristen can help you.
Hi, are you a clerk of court?
Yeah.
Okay. So we have ongoing federal litigation at the United States Supreme Court. The state of Minnesota is not currently part of the litigation, but we need to make them aware. So we've got a notice here with some evidence that's affected litigants within the state. We just need to provide this evidence to you guys. It needs to go to the justices so that they can direct the judicial officers within the state to act in an appropriate, lawful manner. That's the intent that we're hoping to achieve here with what we're doing right now, without any further litigation. So the certificate of service is on the front. My contact information is directly inside. The affidavit is right here. It's very, very simple, very straightforward. If you have any questions, please let me know.
Okay. Sounds good. I will give this to the justice.
Okay, and what was your name, ma'am? Krista.
Yeah.
Okay, thank you so much. God bless you guys. Thank you for service. Service been provided on behalf of the Sheik family here at the Minnesota State Supreme Court. Service provided to the clerk of court, Kristen, I believe her name was Kristen. Thank you so much. We're going to head on out to the next site. God bless. So moments ago, we provided service on behalf of affected litigants here within the state of Minnesota.
When a state chooses to enact its own alternative legislation and then substitute that legislation for the provisions and guarantees of the United States Constitution, that is an unconstitutional act. It is actually the crime of sedition. Sedition is defined as the speaking or writing of words, such as law established, in order to cause disaffection of the Constitution to procure its alteration other than lawful manner. There's one way to change the Constitution, and that can be found in Article 5 of the Special Amending Procedure of the United States Constitution. That is not done by judicial fiat, by executive fiat, or by legislative fiat. It must be done by an authentic act of the people in accordance with the Constitution for the United States of America. So when the state then enacts that inferior law and then directs its agents to enforce that inferior law in violation of the United States Constitution, thus depriving persons of the United States, citizens of the state of Minnesota, of rights guaranteed to them by the Constitution of the United States of America, a crime has been committed. Deprivation of rights under the color of law. Title 18, subsection 242, which states, any person who, under the color of any state statute, ordinance, custom, or regulation, deprives any person of any rights secured by the Constitution, commits that crime. This is a per se crime, meaning that we don't have to prove that they intended to breach their obligation. Simply by virtue of the breach, all elements of crime have been met, because their willfulness and their knowledge derives from the promise they make upon entering their office by oath or affirmation. They have already implicitly provided punishment in the form of perjury should they fail to fulfill the promise. Therefore, it is per se, there's no finding of facts is necessary in order to determine their guilt. All we have to prove is that there was an obligation that existed and they failed to fulfill such obligation. Upon providing notice to the Supreme Court, they have been notified and been made aware of this criminal conspiracy that exists by and between agents of the state, and we now challenge them to step up, discharge the duties of their office, fulfill the obligations and promises they made to the people of the state of Minnesota, and protect the people from crimes being committed by agents of the state. If they choose to do nothing, then they themselves become implicated in the criminal conspiracy due to their negligence, because the laws of criminal conspiracy state any person who, having knowledge of any of the wrongs conspired to be done, and who have the power to prevent or aid in the prevention of commission of same, neglects or refuses to do so, may be joined as defendants in the action. The court has been made aware through their agent. We provided service on the clerk of the court of the Supreme Court right here in Minneapolis, Minnesota. So upon delivery of that criminal affidavit on behalf of the affected parties here, the court has been made aware. Justices, we challenge you, do your job, discharge the duties of your office, fulfill the promise that you made to the people of the state of Minnesota, and enforce the laws of the United States against people that are seeking to destroy them and undermine them. Thank you so much. God bless you, and have a great day.